Imagine a typical business day wherein you're busy with your operations and management of your business, and from nowhere, some polished officers show up at your business premise and forcefully request you to pay taxes or else face the arrest. But how, when, and why does this situation arise? Hold on, I've got hold of my two best men who are ready to answer all of our hows, whens, and whys. A very warm welcome to another interesting and a go-to podcast considering the situation where the business owners are facing force and coercion by the tax recovery officer. This episode is all about knowing your rights and obligations during the investigation under GST law. To answer our questions, let's welcome our two best men, CA Manoj Malpani and advocate Kiran Sawale. Welcome Manoj and Kiran to the Digital Bitsol podcast. It's great to have you both on the show in the times when your both insights are crucially needed.
Yes, hi Rohan. It's good to be back and interacting with you after a long time. And today it's my pleasure. I have my colleague Kiran with me.
Hi Ram.
So it would be a great pleasure for both of us to interact on this issue. Now, Rohan, let me tell you on the today's discussion. It's all about investigation in GST. Now, why we have taken this topic? ये टॉपिक लेने का भी एक रीजन था. पिछले कुछ दिनों से जीएसटी में काफ़ी इन्वेस्टिगेशंस चल रहे हैं, काफ़ी रेड्स चल रही है. एंड मोमेंट ये इन्वेस्टिगेशन और रेड चलती है तो सर्टनली टैक्स पेयर को एक टेंशन आता है कि मेरे मेरे से क्या गलत हो गया, मेरे से क्या चीज़ गलत हो गई जिसकी वजह से स्ट्रेट अवे रेड और इन्वेस्टिगेशन शुरू हो गया. और जब ये किस्से काफ़ी बढ़े तो मैंने और किरण ने ये सोचा कि क्यों ना इस पे एक पॉडकास्ट किया जाए और जिसमें हम टैक्स पेयर्स को क्या राइट्स है ये इन्वेस्टिगेशन में और टैक्स पेयर के क्या ऑब्लिगेशंस है ये दोनों चीज़ हम डिटेल में डिस्कस करें. सो टुडे वी आर हियर बिफोर ऑल ऑफ अस to discuss on rights and obligations of taxpayer during investigation under GST.
My first question for you both is when can a GST officer undertake a search or an inspection?
Yes, Rohal. If you look at CGST Act, Section 67 of the CGST Act very specifically says that, and it empowers an officer not below the rank of Joint Commissioner to undertake investigation, inspection of the premises of the taxable person. If he has a reason to believe, so again, these words are very important. First, what I said is officer not below the rank of Joint Commissioner of GST. So, any officer from Joint Commissioner, those officers can issue, if they have a reason to believe that the taxpayer has suppressed any transaction of supply of goods and services, or the taxpayer has claimed input tax credit more than what it is eligible to them or what is entitled to them, or the taxpayer has indulged in the contravention of any of the provision of CGST Act. So on these three instances, any officer not below the rank of Joint Commissioner can issue order for inspection if they have a reason to believe. Now Rohan, the difference come here is how do you define the reason to believe? Now the revenue authorities may suspect the evasion, but they should have something in concrete with them when they issue inspection orders. Just because they suspect, they cannot issue a inspection or search orders. So it is important that there is some credible information available with those officers about the evasion of tax or about the taking credit more than the eligibility. In such situations only they can issue an inspection. Now if you look at the history, because this provision is not new in the taxation law, this reason to believe and all those things. The Supreme Court has already laid down the principle The Supreme Court, in case of uh, Lakmani Mevani, has clearly stated that there cannot be just a suspicion basis which the inspection has to be done. There has to be some concrete evidence or records with the authorities to order the inspection. And that order, though it is pertaining to income tax, it is squarely applicable for these provisions also, because the wordings are exactly same in the sections. So it is very important, again, as I've said, the inspection orders can be issued by the Joint Commissioner or above on a reason to believe basis that the inspection orders would be issued. Rohan.
My next question is, which rank of officer can inspect the premises or the records?
Yes, Ron, as mentioned earlier, the any officer not below of Joint Commissioner can order in the investigation or inspection of the premises. Now, these officers, if you look at Joint Commissioner or Commissioner, they'll not go anywhere for investigation or inspection of the premises. They have so many taxpayers aligned to them. The Act provides that these officers can delegate the inspection to their subordinates, like Assistant Commissioner or Superintendent or Inspector. So they can authorize them to inspect the premises.
My next question is whether the taxpayer has a right to check the authorization for the inspection of the premises.
Yes, certainly. The taxpayer has right. As I've said, the officers who are instructing inspection can delegate the powers of inspection. That delegation of power has to be in writing. There is a specific form INS. So INS stands for inspection. INS 01, which the Joint Commissioner or officer above the Joint Commissioner has to sign and delegate that. The taxpayer has clear authorities. If somebody is coming for inspection, they can ask for that INS 1, which they can check whether it is rightly authorized by the right officers, basis which the inspection is getting carried out. Let me tell you, Rohan, here that this is a right and which the taxpayer need to exercise properly and humbly. He should ensure that he is not offending the officer who is coming for inspection. At the same time, it is the right of the taxpayer to check that whoever is coming to his place is properly authorized under the Act. So certainly the taxpayer has right. The taxpayer should check that form INS 01 along with the ID card of the officer, so that that identity is matched based on the identity card of that officer.
My next question is, to whom the summon can be issued?
Yes. So Rohan, before deal with this question, summon and inspection, we'll just differentiate this. In inspection, GST authority will come at your premises and start the investigation. In summons, that investigation can be carried out at the office of the GST authority, and you need to go there and attend that summon. So summon is basically to appear before the GST authority at his office. So, Section 70 of CGST Act 1970 empowers the proper officer to issue an summons. Why this summons is being issued? The summons is issued to get the things or any evidences necessary from that the tax person. So, any person of the taxpayer is being called to appear before the tax authority to provide evidences, documents, or anything which is required or necessary for or relating to the taxpayer's operation. So for that purpose, summons is being issued. So in under section 17, proper officer is mentioned, and proper officer is separately defined, or through circular it has been specified that even superintendent of central tax authority can also has a power to issue summons to the taxpayer.
My next question is, so in all this situation, can I authorize someone else to appear? So for example, let's say the summon is issued in the name of Kiran. Can Kiran authorize Manoj to appear?
So Rohan, we need to first see what are the provisions for the summons, and who can attend, whether any other person can attend on behalf of the person to whom summons is issued. So section 70 clearly says, which deals with the summons provision, that it should be the process to be followed which has been given under the civil procedure code. So Civil Procedure Code had set of provisions which deals with the procedures of the summons. So as per section 9 subsection 3 of Civil Procedure Code, it clearly provides that any other person or agent of the person to whom summons is issued can appear and attend summons. So in case if summons is issued to Manoj and he authorizing me to appear and attend the summons, that is very well allowed within the provisions of law. So normally if you see GST authority issues the summons to the big boss, so who are the director owner of that business, they issue the summons in their name. But normally any director or owner, they are not taking care of day to day activity. They don't know even what are the transactions or procedure is being followed while filing the GST return and doing the compliances. So in that case, that person may not having the full facts and knowledge about the procedures. So that particular person to whom summons is issued, he can authorize any person in his company and ask him to appear by giving the reply to the summons that so and so person from our organization will attend the summons. So it is advisable that the company or the businesses or taxpayer should have the board resolution in the name of the person who is appearing and attending the summons.
Now, this question comes out of my curiosity. What happens if I do not cooperate while the or during the inquiry? What are the implications of it?
Right. So suppose if any person is not adhering to the summons, the time and date which has been given under summons, he is not going there, not appearing, or ignoring that summons. So there are the implications. Section 193 and 228 has been specifically is being mentioned normally on the summons. If you see any summons, it clearly says that it is a proceeding as per section 193 and section 228 of Indian Penal Code. So what kind of the implication would be if anybody don't attend these summons? Then this summons and this procedure, this proceeding is being deemed to be called as a judicial proceeding. So judicial proceeding is as defined under the Indian Penal Code Act. If anybody don't attend or ignore this summons or this process, then it has the penal provision under section 193 and section 228. Section 228 of IPC provides that if any person is ignoring the summons or not cooperating, then it will be treated as an interruption to the public servant's work, and it is also considered as an insult to public authority. And there is a penal provision under this section that that particular person may face the imprisonment up to 6 months and with the fine of rupees 1000. Further, under section 193 of the IPC, in case any person is not providing evidences or giving the false evidences, then he is being penalized up to 7 years of imprisonment. So this punishment is very vast. If anybody is giving false evidences, then there is a provision of imprisonment up to 7 years. So Rohan, if anybody is not attending the summons or not adhering to, they should inform that you need a time. But ignoring is not a solution. If you ignore, then you need to face this penal provision, and you can request them to give another date. Then officer definitely gives another date, and you can appear that. So avoiding this summons, it would be risky to the taxpayers if they are ignoring the same.
Let's say if I ignore the summon and do not attend it, what are the implications of it?
Yes, Rohan, if you don't attend the summons or you don't provide information which is being asked in the summons or in subsequent letters, then there is a penal provision under section 174 and section 175 of Indian Penal Code Act. So that person may have to face the imprisonment up to 1 month and fine up to 500 rupees or both. That can be the penalty is being provided if you don't attend summons or don't provide any information which is being asked for.
Now, Manoj and Kiran, this could be a very common question. Will I be arrested for any offense under GST?
Yes, Rohan. Let me tell you, not every offense, under every offense, that person will be arrested. Not under every offense. There are specific offenses under which, in section 69, the commissioner can arrest a person. A commissioner or any person authorized by him can arrest a person. Now, which are those offenses? Those offenses are, if you look at it, those offenses are grave in nature, like if somebody supplies goods without raising an invoice with the intention to evade the taxes. So he supplies the goods and don't raise the invoice and with intent to evade the taxes. That's the first offense. Second is he issues tax invoice but don't supply any goods with intent that a fraudulent transaction would be entered into. So you just issue invoices without supplying goods or services, then in that offense also a person can be arrested. Then third offense is somebody avails the credit knowing that he has not received those goods and services. So in that case also the offense, in that offense also the person can be arrested. Another offense which is specified is if somebody collects the tax. So if somebody collects the tax but don't deposit the tax for a period of 3 months after collection, then also that person can be arrested in that offense. Certainly, there are threshold limits are also specified. If the amount of tax involved is more than 2 crores, then only the arrest provisions are triggered. So, in other words, if the tax amount is below 2 CR, in that situation, the arrest provisions cannot be triggered. So, all these put together, if all offences put together, that amount is going above 2 CR, in that situation only the commissioner can order arrest of that person, and the arrest can be done by the commissioner himself or herself or by any other person he or she is authorizing to arrest.
My next question is continued with the previous question. Is this arrest bailable or non-bailable?
That's very good question, Rohan. The moment arrest comes, certainly in everybody's mind comes that whether I will get a bail or something. So, if we look at section 132, which clearly specifies that which offences are bailable and which offences are non-bailable. Now, I'll tell you which are non-bailable. Now, when the amount of tax involved is more than 5 CR, and the offences which we have discussed just now, like issuing tax invoice without supply of goods or services, or supplying goods or services without issuing tax invoice, or availing input tax credit without receipt of goods or services, or collecting the tax but not depositing within period of 3 months. So all for all these offences, if the amount put together is more than 5 CR, then in such situation the arrest is non-bailable. So it is very important to note by the taxpayer that if the amount involved increases to amount beyond 5 CR, for these offences which we discussed, it would be a non-bailable offence and cognizable offence.
Can a person other than the taxpayer be arrested in this case?
Very good question, Rohan. I'll give you background of this issue. Of late, what when the GST department has unearthed a lot of scam of fake invoices, they noted that the GSTN is taken by in somebody else's name, maybe his peon or maybe his driver or a small person, but those are operated by big V's. So big persons are operating those numbers, but taken in the name of somebody else. Now, when the government has noted that in such situation that small person, maybe driver or peon, they have not got any benefit of that fraud or something. The real culprit is somebody else. So after noting this, recently the government has amended section 132, which clearly states that any person who commits the offense and retains can be also arrested. So with this amendment, even a person who commits it, as I've said, that peon may not have committed anything, somebody else has committed. The one who commits and retains the benefit, the wording is also important, and retains. So he has to commit as well as he has to retain the benefit which he is getting out of that offense. So both these two things one happens, and that person can be arrested under the section 132 of the CGST Act.
So now in India, it's a general practice that usually any taxpayer is consulting someone, a professional or a consultant. So in this case, will a person advising, it can be a consultant, a professional, or anyone, be arrested?
Yes, Rohan, that's a very pertinent and relevant question in this matter. You see, I have been personally threatened with this amendment in the provision. I'm not shy away to say that. In some of our investigations, the officer has said to us that we will invoke this provision against you. But let me tell you and remind you the amendment what has been made. The amendment says that if a person commits or causes to commit and retains the benefit. So both these things has to be fulfilled before arresting any person. And that any person can be anybody. Person can be a consultant as well. If a consultant has causes to commit and also retain the benefit, then only he can be arrested. If a consultant is getting only his consulting fees, he has put all his efforts clearly, he has put all his uh, things in writing to the taxpayer. In that case, invoking this provision against the professional would be difficult for the GST authorities. And if they invoke, that would not be sustainable, Rohan, in the court of the law.
The company is a artificial legal entity, right? In a case wherein there is an offense by the company, who shall be arrested? The managers, the directors, or who?
Okay, Rohan. So, in case of companies, as you've rightly said, company is an artificial legal person. Now, if any offences are committed by a company or a firm, in that case, the directors, the managers who are running that company can be certainly arrested. So, there are specific provisions under the Act which says that in case of companies, the directors, managers who are involved in that decision making would be arrested. Now, here I'll have to put one caveat also. Now, can all directors be arrested in case of offences in the companies? Certainly no. If somebody proves before the GST authorities that he was not involved in that decision making, in that case, that director would be spread. So he would be let away by the provisions of arrest. So he'll not be arrested if somebody proves that he's not part of those decision making. But Rohan, to prove this would be very critical, and certainly it would be before the courts. You have to go before the courts, judiciary, to prove that you are not part of that decision making. The revenue authority by default will say that all are involved. Correct? That's their job. They'll say that all are involved. But then, if you are not involved, you have to prove with the documentary evidences. And that's where the point which Kiran has mentioned comes to an important thing. If you have a clear documentation, resolution defining who does what, then basis that documentation, you can prove that these decisions are taken by XYZ in the organization and I am not directly involved into this. Now you may say that is it a their company are making scapegoats or somebody is scapegoat? Certainly not, Rohan. Now for everything the directors are not responsible. Or many a times the director may or may not know that things are happening which are in a relation of evading tax. So certainly this umbrella of proving and not proving has to be there. Otherwise, every director would be at mercy of these officers.
If a person gets arrested, can you just share us what are their rights?
So, if you see, there are the confessions are being made before the investigation authority. Even in statements are being recorded of the person. If there is a specific provision under the GST law section 136, which clearly state that if any statement is recorded, that can be admitted as an evidence if courts allow so. If courts allow, it can be admitted as evidence, then only it would be an evidence. Otherwise it would not be a good evidence. So it can be seen the statement recorded of the taxpayers, it cannot be a sole evidence against the taxpayer. Further, the as I said, DK Basu guideline has clearly laid down the rights. So the rights which we can discuss here. So first thing is that the boy which is under the age of 15 years and women cannot be called at police station or by the investigating authority at their premises for questioning. So if you have any question, they can ask them on phone or go there and ask them, but they cannot be called for questioning at their premises. If any person is getting arrested, he should know their reasons of the arrest. He should have been informed for what reason he is being getting arrested, and he has a right to inform their friends, relatives, or family member that he is getting arrested. So the person who is getting arrested cannot be deprived of his right that to call his lawyer or her lawyer and the family members. So it is his right to inform first to the relatives or the family members. Then after arrest, that particular statement or memo should be prepared, and there should be a signature of that person who has arrested with that and the officer who has arrested the person. So there should be a signature has been mentioned on the memo which contains the reasons or causes of the arrest. After the arrest, there is a requirement to have the physical examination, and in the physical examination each and every minor injuries has to be recorded. So that is important. Even after the arrest, there should be an medical examination by the qualified doctors of every after 48 hours. So you can see why these provisions are, because there are the ill treatment or tortures being happen in the custody by the during the interrogation. That's why these stringent provisions are there. Further, that during the investigation or interrogation, the person who has arrested has right to consult with the lawyer or the consultant. So he can ask the what kind of reply to be given to the authority or like that. Or during the investigation, he has right to discuss with consultant. Though the lawyer or consultant cannot remain present for the whole interrogation or the discussion, but in between, the person who has arrested has right to consult with the advocate or the consultant, right? So the arrested person must know his rights, and the after the arrest is being done.
So, if a person is under investigation or an inquiry, can he demand for a audio video recording?
So, Rohan, there is no direct provision under GST law which state that the investigation or interrogation should happen in camera, and audio video recording should be there. But there we can see the section 67 which state that any investigation interrogation shall be carried out in accordance with the criminal procedure code. And criminal procedure code has a provision that it has been recently amended, that the any investigation interrogation should have the audio video recordings. Further, the Supreme Court, in case of Paramveer Singh Saini versus Baljit Singh, has clearly given a guideline and directed to the government to install CCTV cameras in the agencies who has power to interrogate and power to arrest. So, in that particular agency list, there is a specifically mention that Director General of GST Intelligence has specifically covered, and these provisions are also applicable to the GST authorities. So, in case if you demand that this investigation or the investigation and interrogation should have the audio video recording, then you can ask the officer and get that entire proceeding recorded. If somebody denies you that particular right to record this discussion, then you can approach to high court and insist for that. That is well within your right.
Now, Manoj and Kiran, the GST law is a fairly new law, and people are still trying to understand it, and many of them are interpreting it in their own language. There could be a slight amount of chance that there can be a misinterpretation of the law. Can a person be arrested for the interpretation issues?
Yes, Rohan, no arrest can be made on only on the basis of interpretation issue. If there is a difference of opinion between the taxpayers and the GST authority with respect to any provision, then no arrest can be made in that cases. So this has been held in case of Honorable Madras High Court, that arrest can be made only in case where there is an offence has been committed, and that offence has been proved by following the proper adjudication process. However, this there is a contradictory view in case of Chaya Devi versus Union of India by the Allahabad High Court. So, as we said in the beginning, that there should be a balance has to be maintained, and that balance has to be maintained and has to be seen by the courts. There is another judgment, is a beautiful judgment by the Honorable Punjab and Haryana High Court, which state that this authority cannot use their tactics and pressurize to the businessmen and create the fear atmosphere. Further, there is a very nice judgment of Punjab and Haryana High Court, which clearly provides the parameters when arrest can be made. So these are the very important parameters which state that the situation where arrest can be made. So they have also stated in their judgment that the arrest cannot be made on the basis of whims and fancies of the authorities. The arrest can be made only in case where there is a genuine offenses, and there should not be an atmosphere of fear in the mind of businessmen. So to avoid this, they have laid down some parameters. I'll read out those parameters for you, which are very important parameters. And it is a illustrative, not the exhaustive things that one should follow. So those points are: a person involved in evasion of huge tax amount and is having no permanent place of business. The next point is a person is not appearing despite of repeated summons and involved into tax evasion of huge amount. Person is habitual offender and has been prosecuted or convicted on earlier occasions. देन अनदर इज पर्सन इज लाइकली टू फ्ली फ्रॉम कंट्री, तो उसको तो पकड़ नहीं सकते जो भग के जा रहा है, तो फॉर दैट दिस प्रोविजन ऑफ कमिटेड और नॉट कमिटेड इन ऑफिस दैट कैन नॉट बी एप्लीकेबल. सो इन दैट केस अरेस्ट इज मस्ट. देन पर्सन इज ओरिजिनेटर ऑफ फेक इनवाइसेस. And then next point is when direct documentary otherwise concrete evidence is available on the file and record that active involvement of that person. These are the broad parameters has been set by the Punjab and Haryana High Court. If these are involved, then only arrest provision should be invoked. But as we aware that these are the only the points which are kept in the documents, and what exactly happens in the industry that everybody knows, and whether this kind of guideline would be followed, that would be the $1 million questions in our mind.
Now, this can be a very generic question, but yet an important one. If the investigation is happening, would it be an overnight investigation, or will it also continue on public holidays or holidays?
Yeah, very right question, Rohan. We have seen the investigation is being also carried out in nights. If you see the payment challan DRC 03, which is being issued in the night, 12 o'clock, 2 o'clock, this kind of investigation is being carried out in the nights, and actually there is no provision under statute that investigation or inspection cannot be carried out in the nights. But in case of there is now a direction given by the Honorable Telangana High Court, which has provided relief to the taxpayer, stating that that investigation cannot be carried out in the night. It has to be carried out in during the working days and between the 10 a.m. to 5 p.m. That has been guideline set by the Honorable Telangana High Court. That is very welcome and good step which has come forward to curtail these practices, to carry out the investigation overnight continuously for 2-3 days without any break, or without employees to go at home and provide the, or support during the investigation.
When the search or the inspection is happening, whether ad hoc tax needs to be paid?
Yes, Ron, it has of late came to the notice, as we discussed earlier, that these officers many a time are behind their collection targets. So when they are behind their collection targets, they'll do inspection, they'll do search, and they'll force taxpayers to deposit the amount of the tax, and that too without following the due process. And when कहते हैं ना कि बोलते जब सिर के ऊपर से पानी जाता है तो सर्टेनली कोई ना कोई कॉग्निजेंस लेता है. In this case, the government has precisely issued instructions, not in the year 2022, but even in the year 2021, clearly stating that there is no mandate to deposit the tax. Rohan, you would be surprised to know that in many investigations, the taxpayer were forced to pay ad hoc amount without even giving them time to compute. Like आज 2 करोड़ भर दो, 4 करोड़ भर दो, and simply not giving time to taxpayer to even compute actual liabilities. So this is not a necessity. The law do not say that you have to pay ad hoc, and even the instructions are very clear. They should not force the taxpayers to deposit. They can come, they can inspect, they can issue me summons, they can ask me information, but they cannot force me to pay the tax on the same day when the inspection is going on, that too without ascertaining the liability. So to cut short the answer to this question, it is not a mandate to deposit tax voluntarily without ascertaining it.
Now, can you help us understand that if the tax officers show up at your business premise and they are conducting the search or the inspection of the records, while that is happening, if there is a demand for tax, right? If there is a force of tax to be paid in that situation, can there be any action that can be taken, or will there be any kind of a some kind of a different treatment for the tax which is paid under that force?
Absolutely, Rohan. It's a very tricky and difficult situation. It's easy to say on the camera, or it is easy to say on the mail that you don't deposit it. But when you look on the ground situation, there may be situation that you are sitting at midnight, or you have been pressurized, or pressurized to an extent that sometimes you really feel that let's pay off and let's decide what to be done next line on that issue, rather than fighting at that point, because always a human tendency, a human would break after a certain period of torture or pressure. So certainly in situations where if the taxpayer has deposited on ad hoc basis, and still the taxpayer feels that there's a difference of opinion, and the deposit is not correctly the tax amount which is ascertained, in that situation the taxpayer can write back after paying the tax ad hoc to the department that he contests that amount, and that letter in writing has to be submitted to the department, so that the department will start judicial proceedings. They'll issue show cause, they'll issue summons, you will submit information, then the tax would be ascertained if at all. So the it is very important that the taxpayer shares that letter or submits that letter to the department if at all they have made any ad hoc payment of tax.
Thank you, Manoj and Kiran, for coming on the show. It was great to have you here and to listen to your insights, suggestions, and recommendations around the current situation. And I hope it was the same for our viewers and listeners.
Yes, Rohan. Whatever we have discussed now, you must have noticed that the GST authorities has wide powers for inspections, for search, for seizures, for arrest. So they have wide powers. Rohan, I'd like to bring to your notice a famous saying in this case. Power comes with responsibility. So my expectation with GST authorities is they have got powers fairly enough. They should have those powers, but that powers has to be utilized with a responsibility. That responsible utilization of powers is what the taxpayers are expecting on a larger picture.
Ron, it is very much important to go to the right person in these cases and the situations. We at Bitsol India have experienced team who can assist taxpayer during the search, seizure, investigation and further litigation arising out of that. We have that experienced team and we are just phone call away for the all taxpayers.
I would like to end this episode with a friendly advice or a suggestion that if you are caught up in a situation like this, the first thing you need to do is not panic. And the second thing you need to do is get an understanding about your rights as well as your obligations under the law. This shall help you face the situation boldly and in a positive way. This is Ron from Digital Bitsol podcast, and we are coming up with more such episodes. So don't forget to like, subscribe, and follow us. Take care.